Hey guys, Zach Anderson with Valley Estate and Elder Law here, back with you to tell you about some ways that you can help avoid a family fight after you pass away. Here's 4 tools that you can use to do that, and they're pretty feasible. First, a trust. A trust, most likely, if it's funded properly and done properly and drafted properly, can at least keep us out of probate court upon death. Probate court is necessarily going to involve all of your heirs at law. In Alabama, that's often children and descendants of deceased children, even if they're disinherited. However, sometimes your heirs can include people like siblings, parents, and even estranged family members like estranged children. It really depends on the context. But nonetheless, a trust is going to have a much, much lower chance of a legal proceeding. Nobody is invited to file a lawsuit in the same way that they might in a probate administration, where we're going through probate and we've got some disagreements and things like that. If the family situation in your family is at least somewhat rocky, that's one of the markers that you may want to run your estate plan through a trust. At least keep it out of probate so that people aren't necessarily invited to air their grievances out in court. The second thing we can do, I love this tip here, is to use a lottery or rotation system. That is empowering your personal representative under the will or your trustee under a trust to say, if someone is, or 2 people are disagreeing over a particular tangible item like dad's watch or this certain gun or piece of jewelry or something like that, the trustee can use a lottery or rotation system to give those items accordingly if they're not spelled out in the will, so that we don't have this, just stalemate where people are fighting over tangible personal property. I really like including this in my documents for that reason. The third tool we might use is a contest clause. In some jurisdictions, it's known as an in terrorem clause. I like using plain English, so I call it a contest clause. Here's what it says. It says if somebody wants to challenge my will, trust, or other instrument, that's fine, but they're going to forego their share under this instrument when they file that contest. Now, different jurisdictions, that is different states, are going to approach these differently. Some courts don't like them. They'll potentially throw them out. Other jurisdictions will look at them. If there's a good faith basis for filing a lawsuit, they might allow it and strike down something like this. Hopefully you have good severability provisions in your wills or trusts. But nonetheless, I do like to include the contest clause just in case somebody's thinking about causing problems. Maybe they read that and think, oh, I'm not going to get my $10,000 or I'm not going to get my $5 million or what have you. Maybe I'll listen to what the personal representative has to say rather than just going in like Rambo and wanting to, fire bullets and start fights. And then the last tool that we can use is mediation. We can encourage mediation in the documents. We can require it. Probably the least impactful on this list, just putting that in the document. However, mediation itself can be very, very powerful, but I just haven't seen that a whole lot of times take someone's heart who is set on fighting and causing problems and kind of soften it. But nonetheless, if we get into mediation, if we can get there, if the documents are followed, we can get some good results out of that. And you guys know probably from just general life experience how mediation goes. Try it. It's a good first step. Sometimes we can mend hearts and get the situation done in a more cost-effective manner. Everybody sort of wins in that way. But, at some point, maybe it doesn't work and you go on to the next realm there. But nonetheless, it's a good first step. These are 4 tools you can use to reduce family fighting over your inheritance after you pass away. And I hope you found this video helpful.